All right, Mr. Harris, I've been handed a document indicating you want to enter a plea of nolo contendere or no contest to count one, child endangerment, a Class B felony, which is amended to aggravated assault, a Class C felony. Receive a sentence of 1 to 3 years. Count one is 1 to 3 years. I'm sorry. Count one, 3 years suspended of probation, court costs, and he'll be required to continue to comply with the Department of Children's Services requirements. 0 tolerance for drug screens. Count 2 would be amended to Class A misdemeanor, and it would be 11 months and 29 days in county jail, suspended to probation, concurrent with count 1. All right, raise your right hand. Let's place you under oath.
You solemnly swear or affirm the testimony you're about to give will be the truth, whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Harris.
All right, step in front of that microphone and speak up.
Harris.
Mr. Harris, you're here today charged with a 2-count indictment. You've heard me go over what the agreement is, but have you seen or been shown a copy of those charges? Talked them over with your lawyer. You and Mr. Taylor discussed the range of punishments you're facing as well as any possible defenses you might have. Well,
yes, sir.
Well, it's indicated you want to enter a plea of nolo contendere. You've heard me say all that means is that you're not going to admit you did anything wrong, but you're not going to contest the state's evidence when the state tells me what their evidence would be at trial, and that evidence will be used to find you guilty. Do you understand that?
Yes.
You understand you have the right to plead not guilty and to have a speedy and public trial by jury in this court.
Yes.
You understand that you would have the right to have a lawyer and to have one appointed if you cannot afford your own, and of course we've done that with the public defender's office.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of any crime. You understand that if you went to trial, you and Mr. Taylor could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by the use of a subpoena.
Yes.
You understand that you would be presumed to be innocent. You would not have to testify at trial or produce any evidence, and no inference of guilt would arise because you did not testify at your own trial. You understand that you would if you went to trial, you were found guilty, you would have the right to appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes.
You understand that by pleading no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
But do you understand that's going to result in 2 convictions that are going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
You want to plead no contest according to this agreement and waive your right to a trial and to an appeal.
Yes.
Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this against your will?
Yes.
You understand I can't accept your plea unless I'm satisfied you're guilty and that there are facts to support it.
Yes.
And I want you to step aside and listen as the state tells me what their evidence will be if this case went to trial.
Your Honor, if this matter went to trial, the state would have put on proof that in February of this year, Sergeant Jacob Booth from the Houston County Sheriff's Office received an email from DCS containing the results of hair follicle tests for Mr. Harris's children. They did test positive for methamphetamine. Mr. Harris admitted to smoking meth outside of the house. That must have been cross-contaminated over to the children, Your Honor. I will say that originally, I had offered time to serve, but I received all the reports from DCS and juvenile court, and this is Miss Carly's companion case. They're passing all their drug screens, they're doing all the therapy, and they are fully cooperating. And the state hope that continues. I think it just shows that if you work with the court system, that things can get better. They're doing great so far. That would be the proof.
I'm not asking that you agree with those facts, Mr. Harris, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney services?
Yes.
You feel like you have been represented competently by Mr. Taylor?
Yes, sir.
Mr. Taylor, do you know of any reason he should not enter this plea?
No, Judge.
You like your children?
I love them.
You love them. Why in the world would you expose them to a drug that could be potentially dangerous and deadly to them? Especially, I mean, they don't have a choice. You have a decision. You can make a choice to smoke meth or use meth, however you use it. That's your decision. but they don't have a choice in it. And as a result of that, you have put your children in a dangerous situation, endangered their health. I mean, they tested positive, for God's sake, for methamphetamine. How old are they?
Catherine's 11. Levi's gonna be 5 in a couple days, and Ambrose.
You want your 11 and 5-year-old to end up on meth?
No.
You want them to end up drug addicts? Let me just tell you this. I hesitate to even approve this because of the fact that you really ought to serve time in prison for exposing your children to methamphetamine like that. But because the state has investigated thoroughly, and I trust General Allen's judgment, the fact that you are doing everything you're supposed to do to try to correct this problem, this is your one and only opportunity to avoid going to prison for this case. Do you understand that?
Sir.
If you come back in front of me or one of the other judges and you've tested positive or you expose your children to some other kind of a drug, then you're going to go to prison for this sentence as well as anything else that you can get. But you're also given an opportunity to set this aside and give your children a productive life down the road. It's up to you what you do. They don't have a choice. They're the true victims in this case. Sometimes they say drug use is a victimless crime. Not if you expose your children to it. They're truly victims. So I want you to understand that I mean what I say. One positive drug screen, and you're going to prison. You understand that? That way I'll know that the children aren't being exposed to drugs if you're in prison. They'll be in somebody else's care and custody. I don't want to do that. I'd like for you to straighten up and give your children a productive life so that you look back on it years from now and realize that that this is just a blip on the horizon of trying to get your life straightened out. So, all right. Then I find you guilty upon your plea of no contest to count one, sentence you to 3 years in Tennessee Department of Corrections that will be suspended to probation. You are to continue to comply with the Department of Children's Services requirements with a zero tolerance, and that means what it says, for a positive drug screen. Count 2, you're found guilty, sentenced to 11 months and 29 days in county jail that was be suspended and will be on probation concurrent with the other case. That's a judgment report. He needs to see the probation department before he leaves.
And Judge, I just want to make clear, and I think I've talked to him about this, but THC, although there's sort of a gray area with regard to that, the stuff you can buy down here, that's zero tolerance. You can't have any THC in your system either.
PCS hadn't really cared about that. No.
THC meaning marijuana?
Yes.
Well, let's just make it clear.
Yes.
Whether I agree with the laws about marijuana or not doesn't matter. My job is to enforce the laws, and it is illegal to use marijuana. Now, there are all these THC products that supposedly do it. If I was in your shoes and I was looking at going to prison for 3 years, I would do everything I could. Drink all the caffeine you want, use anything else that you want to, but don't do something that could potentially land you in prison. And if you come back and the Department of Corrections comes to me and you've tested positive for THC, you know what's going to happen? Again, whether I agree with it or not, that doesn't matter, because there are legal ways that you can obtain THC, or at least of some small amounts of it. But again, we used to have Judge Alan Wallace sat in this courtroom, and I stood right there where Mr. Taylor was representing a guy. And what he told him was, he said, son, you better live at the foot of the cross for the next 3 years. And that's exactly what you need to do. So you did not do anything that could potentially put you at peril, because I don't have any qualms about sending you to prison if, in fact, you do something that's going to put you at risk. You understand that?
Yes.
All right. I do wish you good luck in trying to get your life straightened out, and I hope you'll take what I've said as meaning that it's intended to try to let you know how serious and how close you came to serving time in prison. All right, good luck. See you at probation before we leave.
Your Honor,